Sir, step away from that door. Are you trying to force entry?
I'm unlocking my office. I work here.
After hours? That's suspicious. I need to see ID.
It's inside, on my desk. That's why I'm opening the door.
Don't reach for anything yet.
So I can't open the door and I can't prove I work here?
I just need cooperation.
You're getting it from the public defender or something?
Officer Jason Kier had served with the Portland Police Department for 3 years, but his time there was marked by a recurring issue that his supervisors consistently overlooked. Over 36 months, he faced 11 complaints, all tied to stops where he assumed someone was committing a crime based on how they looked rather than actual evidence. One Thursday night in downtown Portland, Kier made a choice that would cost the city $7 million and end his law enforcement career for good. David Richardson, a 34-year-old lawyer, was trying to unlock the door to his own office, Suite 431 on the 4th floor of a downtown building, after realizing he had left his ID badge inside. No crime, no break-in, no complaints, just a lawyer working late doing exactly what thousands of professionals do every night in office buildings across the country. But Officer Kier saw something completely different. He saw a black man in business clothes standing at an office door after hours, and his bias led him to believe something illegal was happening. That mistaken assumption sparked an unlawful detention, a wrongful arrest, and consequences that would reveal a department-wide failure to tackle racial profiling. Before we go on, where are you watching from? If this is your first time here, hit that subscribe button. Stories like this need to be told, and your support helps us bring more truth to light. Downtown Portland, Oregon, the Pearl District, where tech startups share space with law firms and consulting companies. Modern office towers with glass fronts reflecting city lights. It's the kind of place where professionals work late into the night chasing deadlines, where security guards know the regulars by name and no one questions someone entering an office at 10 p.m. It was 10:41 p.m. on a Thursday in July. The summer sun had long gone down. The building's hallways were quiet but not completely empty. Fluorescent lights buzzed softly overhead. The elevator chimed occasionally as other late workers came and went. Normal, safe every day. David Richardson had been a public defender for 9 years, 9 years representing clients who couldn't afford private lawyers, 9 years standing up for people the system had already labeled guilty, 9 years in courtrooms negotiating plea deals, preparing for trials, and reviewing evidence until his eyes ached. His coworkers called him relentless. His clients called him a lifesaver. Judges respected his thoroughness. Prosecutors knew he didn't back down. He had graduated with honors from Lewis and Clark Law School and had clerked for a federal judge. He could have taken a corporate job earning 3 times his public defender salary. But that wasn't why he had gone to law school. At 16, he had watched his own uncle get railroaded by the system, an overworked public defender, a coerced confession, and 15 years for a crime he didn't commit. That experience shaped David's entire path. He chose public service. He chose to stand up for the people who needed him most, and 2 years earlier he had opened his own practice, taking on criminal defense cases on a sliding scale, handling clients other lawyers avoided because they weren't profitable enough. His office was Suite 431 in a mid-rise building on Northwest 10th Avenue. A small space, 1 room, a desk, 2 chairs for clients, filing cabinets stuffed with case files. His law degree hung on the wall beside his bar admission certificate. It wasn't fancy, but it was his. That evening he had been working on a motion to suppress evidence for a client whose Fourth Amendment rights had been violated during a traffic stop. The irony would not be lost on him later. He worked until his eyes could no longer focus. Just after 10:30 p.m. he packed his laptop into his messenger bag, grabbed his suit jacket, and headed for the elevator. He wore charcoal gray slacks, a white dress shirt with sleeves rolled up, and black leather shoes. His messenger bag was slung across his shoulder. He looked exactly like what he was, a professional finishing a long day at the office. He reached the elevator, pressed the button, waited, and then realized his employee ID badge was still on his desk. He needed it to get into the parking garage. Without it, he couldn't access his car. So he turned around and walked back down the hallway to Suite 431. He pulled out his keys, picked the office key, and inserted it into the lock. Completely normal, completely legal, completely innocent. But Officer Jason Kier didn't see it that way. Kier had been assigned to downtown patrol that evening. His shift started at 10 p.m. He was supposed to be monitoring the bar district, checking on business closures and responding to noise complaints, standard Thursday night duties. But Kier had a habit of wandering into office buildings. He would cruise through parking garages, walk hallways, and check door handles. In his mind, he was being proactive, preventing crime before it happened, catching burglars before they could steal anything. His supervisors had never told him to stop. In fact, they had praised his initiative. Kier had made 6 trespassing arrests in his 3 years on the force. Never mind that 4 of those arrests were dismissed because the people he detained actually worked there, or that the other 2 led to complaints of excessive force. The department counted them as wins, proactive policing, prevention. That evening, Kier entered the building on Northwest 10th without any call for service. No alarm, no complaint, no reason. He simply walked in through the unlocked lobby and took the elevator to the 4th floor. When he stepped out into the hallway, he immediately saw David Richardson at the door to suite 431, key in hand, unlocking his own office. And in that moment, Officer Jason Kier's bias took control. He saw a black man in business clothes at an office door after hours. In Kier's mind, that could only mean one thing. This wasn't a professional working late, it was a burglar in disguise trying to break in and steal computers, files, or valuables. Kier didn't think about the man having a key. He didn't consider the professional attire. He didn't consider that there might be an innocent reason. He just acted. Do you think officers should be allowed to enter private buildings without cause? Drop your answer below. Officer Kier strode down the hallway toward David, hand moving toward his belt, voice loud and commanding. Sir, step away from that door. The words echoed through the quiet corridor. David turned, surprised. He saw the uniform, the badge, the aggressive stance. He'd been in similar situations before, not often, but enough to know how easily things could go wrong. Good evening, officer, David said calmly, keeping his hands visible, the key still in the lock. What can I do for you? Trying to force entry. Kier's tone was accusatory, confrontational. David blinked. Force entry? I'm unlocking my office. I work here. After hours, Kier stepped closer. That's suspicious. I need to see ID. David felt the familiar weight of frustration settle in. It's on my desk, that's why I'm opening the door. I forgot it when I left a minute ago. Kier's eyes narrowed. Don't reach for anything yet. And there it was, the moment when a completely innocent act was treated as a crime. David Richardson, a licensed attorney standing at his own office door with his own key, was being treated like a suspect because Officer Kier couldn't imagine that a black man might actually belong there. So I can't open the door, David said, his voice steady but laced with controlled frustration. And I can't prove I work here, Kier replied as if that explained everything. David looked directly at the body camera on Kier's chest. You're getting it, he said quietly. The statement should have made Kier pause, should have made him reconsider, should have triggered the thought that he might be wrong, but it didn't. In Kier's mind, criminals claim to be everything: lawyers, doctors, business owners. It was a way to deflect responsibility, to avoid accountability. This is where bias becomes dangerous. Kier had already made up his mind. Black man at an office door after hours wasn't a professional working late. It was a crime in progress, and no explanation was going to change that. I need you to step away from the door and put your hands where I can see them, Kier said, his hand now resting on his service weapon. David's jaw tightened. After 9 years arguing in courtrooms about unlawful stops, unreasonable searches, and constitutional violations, he was now living it. Officer, David said, keeping his voice calm. My name is David Richardson. I'm an attorney. This is my office, suite 431. My name is on the door. My bar card is on my desk. I have a key because I own this practice. You're stopping me without probable cause. Kier moved closer. I'm investigating suspicious activity. What suspicious activity? David's voice rose, frustration breaking through. I'm unlocking a door with a key. That's not suspicious. That's normal at this hour in an office building. Yes, David said firmly. Attorneys work late. That's what we do. Look at the door. The sign says David Richardson, attorney at law. That's me. Kier glanced at the small placard on the door, suite 431, David Richardson's office. But instead of stepping back or apologizing for the misunderstanding, Kier doubled down. I still need to verify your identity. Then let me open the door so I can show you my ID, David said, patience thinning. No, you're not going inside until I can confirm you have a right to be here. This is insane, David said, shaking his head. You're detaining me for entering my own office. Turn around and put your hands behind your back, Kier ordered. David's eyes widened. You're arresting me. I'm detaining you pending verification. Verification of what? I've told you who I am. I've told you this is my office. I have a key. What more do you need? Kier reached for his handcuffs. Turn around. In that moment, David Richardson, a public defender who had spent his entire career fighting this exact kind of abuse, faced a choice: comply with an unlawful detention and allow the system to violate him, or resist and risk escalation. He chose to comply because he knew what often happened to black men who didn't. Should attorneys be immune from wrongful stops in their own workplaces? Let me know what you think. David turned slowly, hands raised. I'm complying under protest, he said clearly for the body camera. This is an unlawful detention. I'm an attorney entering my own office. You have no probable cause, no reasonable suspicion, and I will file a complaint the moment you release me. Kier pulled David's arms behind his back and snapped the handcuffs on. The metal dug into David's wrists. The indignity burned deeper than the physical discomfort. This is what racial profiling looks like when it comes with a badge. A black attorney in his own building, at his own office with his own key, being handcuffed because an officer couldn't imagine he belonged there. A door opened down the hallway. Another attorney, Sarah Chen, who worked 2 suites over, stepped out. She had heard the raised voices. David, she called out, confused. What's going on? David turned to her. Sarah, I'm being arrested for trying to enter my office. Sarah hurried toward them. Officer, that's David Richardson. He's a public defender. That's his office. He works here every day. Kier barely looked at her. Ma'am, step back. This is police business. Police business? Sarah's voice rose. He's been in that office for 2 years. I've worked with him on cases. This is ridiculous. Ma'am, I'm not going to ask again. Step back. Sarah pulled out her phone and started recording. I'm calling building security and the Bar Association. This is harassment. Kier radioed for backup. Dispatch, this is Unit 15. I need another unit at 1040 Northwest 10th Avenue 4th floor. Possible trespassing arrest. Also have an uncooperative witness on scene. Within minutes a second patrol car arrived. Officer Linda Torres stepped off the elevator. She'd been on the force for 12 years and had worked with Kier before, learning not to trust his judgment. What's the situation? Torres asked. Kier pointed toward David. Caught this individual attempting to break into an office. He claims he works here but has no ID. Torres looked at David, then at the door, then at the sign clearly reading David Richardson's office. Kier, she said quietly, his name is on the door. Could be coincidence or he could be using a stolen key. Torres walked over to Sarah, who was still recording. You know this man? Yes, Sarah said immediately. That's David Richardson. He's an attorney. This is his office. He's here almost every night working late. Officer Kier is making a huge mistake. Torres turned back to Kier, voice dropping to a sharp whisper. Uncuff him now. I was investigating suspicious activity. You are racially profiling a professional in his own building. Uncuff him before this gets worse. Kier hesitated, his face flushing, but the damage was done. The body camera had recorded everything and the witness was filming. The evidence was undeniable. He unlocked the handcuffs. David rubbed his wrists, jaw clenched, fury radiating from him. Torres stepped forward. Mr. Richardson, I apologize. This should never have happened. Would you like to file a formal complaint? David looked at her, then at Kier, then at the camera still recording. Yes, he said, voice tight. I absolutely would, and I'll be filing a lawsuit. This wasn't an investigation. It was racial profiling, plain and simple. Building security arrived moments later. A supervisor named Marcus, who had worked there for 6 years, immediately recognized David. David, what the hell is going on? I was arrested for entering my own office, David said flatly. Marcus looked at Kier with disgust. This is David Richardson. He's one of our regular tenants. He's here late almost every night. Everyone knows him. Kier said nothing. There was nothing to say. He had profiled an attorney in his own building, arrested him without cause, and been proven wrong by multiple witnesses. Torres radioed dispatch. Cancel that backup. Situation resolved. Flag this incident for supervisor review. Why do some officers see professional success in black individuals as suspicious rather than normal? Share your thoughts in the comments. By morning, the story had reached the Oregon State Bar Association. A licensed attorney handcuffed in his own office building while simply trying to enter his own suite. The outrage was swift and intense. The Portland Police Department received the formal complaint by noon. David Richardson's attorneys, of course he had attorneys, colleagues who had worked with him for years, filed a comprehensive civil rights lawsuit within 48 hours. The allegations were severe: unlawful stop without reasonable suspicion, false arrest without probable cause, racial profiling, violation of constitutional rights, emotional distress and reputational harm, and failure to train officers on implicit bias and reasonable suspicion standards. The body camera footage told the entire story. David identifying himself, David explaining he worked there, David pointing to his name on the door, and Kier arrested him anyway. The city's attorneys reviewed the case and reached a grim conclusion within a week. This was indefensible. The evidence was overwhelming, the violation clear. Settlement negotiations began immediately. 8 months later, the city paid $2,700,000 to David Richardson, funded by taxpayers, covering the cost of one officer's bias. Officer Jason Kier was terminated 10 weeks after the incident. The termination letter was final and unmistakable. Officer Kier engaged in racial profiling and unlawful arrest. He detained a licensed attorney entering his own office without probable cause or reasonable suspicion. His actions violated department policy, state law, and federal civil rights protections. His employment is terminated immediately. Kier's name was added to the National Decertification Index. He would never work in law enforcement again, not in Oregon, not anywhere. He tried to appeal through the police union, but the union withdrew support once the Oregon State Bar Association filed a formal complaint and the body camera footage became public. Kier released a brief statement through an attorney. I made an error in judgment based on incomplete information. I take responsibility for my actions and apologize to Mr. Richardson. It wasn't enough. It would never be enough. The Portland Police Department faced intense scrutiny from civil rights organizations, the Bar Association, and the Department of Justice. How had Kier, with 11 prior complaints involving racial bias, remained on patrol? Why had supervisors ignored the pattern? What training existed to prevent officers from profiling professionals in their own workplaces? Internal Affairs launched a thorough review. What they found was systemic negligence. Complaints had been filed but never properly investigated. Training requirements were completed on paper but not truly absorbed. Supervisors were pressured to close cases quickly to meet administrative quotas rather than address the real problems. The Department of Justice launched a pattern and practice investigation focusing specifically on stops in downtown commercial areas. Reforms were announced within 6 months: mandatory de-escalation training before any solo patrol assignments, real-time body camera review for all detentions in commercial buildings, a dedicated civil rights unit to investigate discrimination complaints, and extended probationary periods with psychological evaluations for officers showing signs of implicit bias. David Richardson became an advocate, even though he never sought that role. He testified before the city council, spoke at community forums, and gave interviews to local and national media. His message was consistent. "I had every advantage," he said during one testimony. "I'm an attorney, I know my rights, I have resources. I have colleagues who could help me, and I still got handcuffed in my own building for the crime of being black after business hours. What happens to people who don't have those advantages? What happens to delivery drivers, janitors, security guards, people who work night shifts and look suspicious to officers trained to see black skin as a threat?" He paused, voice breaking slightly. "I defend people every day who have been stopped, searched, or arrested without cause. I argue Fourth Amendment violations in court. I fight against this exact abuse. And then I lived it myself in my own office with my name on the door, because Officer Kier looked at me and couldn't imagine I belonged there." The courtroom where he testified was silent. David donated part of his settlement to organizations fighting police misconduct. He created a legal fund to help people without resources file civil rights complaints. He trained other attorneys on documenting and litigating unlawful stops. But the anger remained, the knowledge that he had been violated in his own workspace, the memory of being handcuffed while Sarah recorded and Marcus vouched for him. None of it mattered to Kier, who had already decided he was a criminal. Should officers face personal financial liability for racial profiling cases? Share your thoughts in the comments. This wasn't just a bad stop. It was a clear example of how bias operates when combined with authority and unchecked discretion. Officer Kier didn't see an attorney working late, he saw a black man who must be doing something wrong. His bias was so deeply rooted that he ignored the name on the door, the key in the lock, the professional attire, and the calm explanation. None of it registered because his worldview couldn't accept a black professional in that space. This is what systemic racism looks like when it's quiet and procedural, no violence, no slurs, just the assumption that black people don't belong in professional spaces after hours. Just the refusal to accept explanations that would be immediately believed from white professionals. Just the use of safety concerns as a justification for profiling. And when that bias comes with a badge, handcuffs, and the authority to arrest, it doesn't just harm individuals. It sends the message that success, education, and professional achievement don't protect you from being seen as suspicious. It tells black professionals they will always have to prove they belong, even in their own offices. Jason Kier's career is over. That's accountability. The city paid $2,700,000. That's justice, at least financially. But money doesn't erase the trauma. It doesn't undo the humiliation of being handcuffed in front of colleagues. It doesn't restore the sense of safety in your own workplace. The real question is, what changes now? Will the department finally take the 11 prior complaints seriously before they become 12? Will they finally train officers to recognize that professional spaces include black professionals? Will they accept that proactive policing can't mean assuming criminality based on race and time of day? Because if we don't fix the system that put Jason Kier in that hallway, if we don't address the bias that led him to see a black attorney as a burglar, then we're just waiting for the next officer, the next victim, the next person who has to prove they belong in their own building. Comment if you think this should become national law. Any officer who arrests someone in their own workplace, proven by documentation, should face immediate decertification. No appeals, no second chances. And if you believe stories like this need to be told, if you think accountability matters and reform begins with awareness, hit that subscribe button, because we're going to keep exposing these patterns. We're going to keep demanding better. We're going to keep fighting for professionals who deserve to work late without being treated like criminals. This isn't just about one officer or one attorney, it's about all of us and the system we're willing to accept.